I'm gonna stand. It's a skirt. It's painted. It's a leather vintage like pencil skirt.
Well, good morning, you two. Welcome to. I know you've been wearing a lot of really cool flowery outfits for this because, of course, you play a florist. Through that little number, that looks great.
Oh, it's so cute. Do you want to see?
Yep.
I'm gonna stand. It's a skirt. It's painted. It's a leather vintage like pencil skirt. And then this is a top that's printed from the painted Dauphine. She's a New York City designer.
That one's bang on brand, isn't it?
Yes, lots of flowers. You're wearing flowers.
I mean.
Hi, besties. It's Katie from Without a Crystal Ball. We have a lot to talk about right now, but first of all, I just wanted to share something because yesterday we talked about the motion to dismiss being granted by Judge Lehman, and I had so many thoughts and I was very emotional and I made a video and I didn't go into a lot of detail. I just shared the overview because quite honestly, I was having a hard time processing it and I was sad for them. I felt bad. I felt like they put so much effort into trying to show the judge what they had and what they didn't have and the beliefs that they had. And I thought that the judge would at least give them the space to go through the discovery process. But instead, he took it off the table and he said that everything related to litigation privilege and the privilege that's afforded to the New York Times. So when he dismissed the case, he said that they could actually refile amended complaints relating to 2 causes of action. So I wanted to talk about that. And I also wanted to share with you a statement from Brian Friedman. So this is what he had to say about yesterday's news. Miss Lively and her team's predictable declaration of victory is false. Let us be clear about the latest ruling. While the court dismissed the defamation-related claims, the court has invited us to amend 4 out of the 7 claims against Miss Lively, which will showcase additional evidence and refined allegations. This case is about false accusations of sexual harassment and retaliation and a non-existent smear campaign, which Miss Lively's own team conveniently describes as untraceable because they cannot prove what never happened. Most importantly, Miss Lively's own claims are no truer today than they were yesterday. And with the facts on our side, we march forward with the same confidence that we had when Miss Lively and her cohorts initiated the battle and look forward to her forthcoming deposition, which I will be taking. We are grateful for the organic show of support from the public and for the dedication of the internet sleuth community who continues to cover the case with discernment and integrity. Aw, thanks, Brian. You're so sweet. He said hi to us. Okay. There's a lot right there, but most importantly is they're going to file new allegations. They're going to refine the case and they're going to be looking into contracts. So that got me thinking about something. Defamation and civil extortion is off the table. Civil extortion was always going to be super hard to prove because it's a law that's in California and really no other state. And California itself doesn't ever really prosecute it, or it rarely shows up in civil cases because the state can't even really decide if civil extortion exists. Absent actual physical threat, it's also very hard to prove. And as the judge noted, even though she received certain benefits, Wayfair had full control and never really acquiesced in that they could have sued her at any time and they didn't. So let's kind of dive into something that I've been thinking about because in the middle of all of this, I think one thing that we need to remind everyone of is that part of the problem with Justin Baldoni's case was that he was in the middle of a crisis when Blake filed that, and it was an immediate public backlash against him, and he was losing his agency, his talent agency. He lost awards. He was basically publicly rebuked by so many different people, and he was labeled effectively like a sex pest, right? And he had to do something quick. And the complaint that they put together, in my opinion, was kind of sloppy because it was all over the place. They interwove so many different storylines. And I think that caused a little bit of confusion when trying to put together a solid claim for each of the arguments. And trying to claim defamation based on the CRD complaint was always going to be a challenge because they were always going to fall behind the protected litigation privilege of it being part of a court record or public record. With that said, that doesn't mean that the details provided in that case don't help his defense, right? And something that I was thinking of as well is that another factor that really impeded his case was that they had suspicions that they knew something was happening, but they didn't have the concrete proof. They just knew it was happening. Do you know what I mean? Sort of like how Blake thinks there's an untraceable smear campaign, but they have more proof than that because they know it's traceable. They just don't have the records to prove it yet. And with that said, they also didn't have a copy of the subpoena. And having a copy of that subpoena from the Van Zandt lawsuit would have really helped them in so many ways prove more malice. But Blake Lively is intentionally withholding it from them, and so is Stephanie Jones. And Stephanie Jones and Blake Lively, in many ways, have taken legal loopholes, which I've told you are common with narcissists, to, in some ways, outwit Justin Baldoni's team. They were already ahead, and so Justin's playing catch up, trying to catch up, and that's hard. That's a very hard place to be. And then also, when you come out swinging and fight back immediately from sexual harassment claims, you're already behind the 8 ball as well, because it's going to look like anything that you say or do could be done in retaliation. And that's a very uncomfortable place to be. And for some people, because of that, the optics of that, they won't file a lawsuit. They'll just defend themselves. Justin still gets to defend himself against the claims that she made, right? But he also gets to bring causes of action related to contract. So, what are those causes of action that Friedman says they're going to be looking into? The judge all but removed Ryan Reynolds from the conversation with his decision, and he stated that he would allow him to amend 2 claims. One would be breach of implied covenant and good faith and fair dealing, which was against Lively. He's also going to allow them to amend intentional interference with contractual relations against Reynolds and Lively still. I don't know if he'll use Reynolds or if they're just going to go after Lively. And then the judge dismissed Reynolds from causes 6 and 7, but he did not dismiss Lively. Okay. So it says he has the 6th cause of action, which is intentional interference with prospective economic advantage and negligent interference with prospective economic advantage. That's related to the WME case. So those causes of action, 4 was related to Lively's contract and that she frustrated Wayfair from receiving all the benefits that were contemplated under the contract. She interfered with the production by making repeated threats and demands in order to seize control over the production, editing, and marketing of the film, such that the Lively parties were deprived of the opportunity to produce, edit, and market a film as contemplated by the contract. By doing so, Lively did not act fairly and in good faith, and they were harmed by her conduct. So, a breach of implied covenant of good faith and fair dealing isn't a complete breach of contract, and we'll get there in a second, but this is all about how she did things outside of her contract that were not exactly a breach, but her behavior itself injured them so much that they didn't get to receive the full benefits of what their job was, which was to make a movie. The other cause of action against Lively is intentional interference with contractual relations, and that is relating to prevented performance of the contract or made performance more expensive or difficult. Specifically, upon information and belief, Lively and Reynolds made threats and or demands to induce WME to cease performing under its contract with the Wayfair parties. They intended to disrupt the performance of this contract, or in the alternative, knew that the disruption of the performance was certain and substantially certain to occur, and that they're claiming caused them harm, and that each Lively parties and Reynolds were aware that the others planned to commit the tort of intentional interference with contractual relations against the Wayfair parties, and that they agreed that with one another and intended that the wrongful acts pleaded herein be committed, and that they did this with oppression, fraud, and malice. And then The 6th cause and the 7th cause were dismissed by him, the judge, in a footnote, but they were not dismissed against Blake in the same footnote. So they were only dismissed against Reynolds. So they can still sue her for intentional interference with prospective economic damages. And that allegation is that Wayfair and WME were in an economic relationship that probably would have resulted in an economic benefit to Wayfair, and that they knew of the relationship. They engaged in wrongful conduct, specifically by making threats and or demands to WME to terminate its economic relationship with Wayfair, and that by engaging in this conduct, they intended to disrupt the relationship, or in the alternative, knew that it would be certain or substantially certain to occur. So they've removed that from Reynolds, but that still applies to Lively, and that they say that was done with fraud and malice. And then negligent interference with prospective economic advantage is only against Lively again. And that they were in an economic relationship with WME, and that they Lively failed to act with reasonable care. And they should have known that they should have, and that their behavior would disrupt their contract, and that they did disrupt the contract. And as a result, Wayfair was harmed. So the judge noted that Wayfair's argument on 23 was what was going to allow them to refile these claims about this contract with WME. And this is what their argument was. Reynolds' others' arguments that the specific details of the contracts with WME are not sufficiently described, and that Reynolds' knowledge of these contracts is alleged only in general terms, are easily curable issues with the Wayfair parties should be permitted to address by repleading. Reynolds himself is alleged to be a client of WME, and the context of an industry in which WME represents many prominent film actors and directors on identical or nearly identical terms by procuring engagement for them and receiving commissions as a percentage of earnings, give rise to the inference that Reynolds, one of the most successful actors, understands the contractual terms by which talent agencies, specifically WME, are bound. Further, contrary to his disingenuous argument that the FAC clearly identifies Baldoni and Wayfair as the Wayfair parties who are represented by WME. So they will provide a copy of the WME contract to prove that he intentionally interfered with their contract. And so they have an opportunity to bring their contract into this conversation. And then they also have an opportunity to bring in the contract for Blake Lively. And what I thought was interesting throughout the entire time was that Blake kept continuing to sign her contract, and she suggested that she wouldn't sign it unless she got certain things, which the judge referred to as hard bargaining. However, once the film was out and she finished her requirements and she was paid, even if she never signed that contract, she still is bound by the terms of that contract because she was paid for what she did. And when Blake Lively signed the 17-point contract agreement, the rider, she acknowledged that there was an actor agreement that had been dated on the May 5th of 2023, and that it was between It Ends With Us Movie LLC and Blakel Inc. And it was related to acting services of Blake Lively to work on the picture It Ends With Us. And in her agreement that they added these new stipulations that she would get, and it says, in the event of any conflict between the terms and conditions of the agreement and the terms and conditions of the side letter agreement, the terms and conditions of the side letter agreement shall control. But she wasn't paid based on this agreement. And so her acting agreement is separate from the side letter and doesn't necessarily conflict with what she has here. And this side letter that she gave to the court, Blake Lively didn't sign anything in this contract that says she gets her own edit of the film. It doesn't say that she gets to hire her own editor. It doesn't say that she gets to hire her own composer, or even that she gets to edit her own cut of the film. And I think that's going to be a big problem for her. She did get a little bit more control here with her 17-point agreement, but not everything that she's accused of doing by Wayfair was covered under the 17-point agreement, specifically as it relates to the promotion of the film, the making of the trailer, the composer, the wardrobe issues, and the like. And so If there's nothing in her contract that says that she doesn't get to make a cut of the film, that can definitely be an issue here. And if she has an actor's agreement that says that she will actively promote and be a part of the process, and she didn't, and she was threatening not to, that could actually be in the favor of Wayfair. What this means for Blake is that her contract, the full contract, is going to be provided by Wayfair. The full contract of his WME contract, Mr. Baldoni's will and Wayfair's will be provided to the court. And if her full contract, her actor's agreement, is in contrast to what she was allowed to do and she didn't have the rights to see, this could be a problem for her when it comes to the claims that they have against her. But all of this is to say that none of this changes the fact that Wayfair still gets to defend against the claims that she's made against them for sexual harassment, which is what Mr. Friedman said in his statement, that this case is about false allegations of sexual harassment, and they are still going to defend themselves, and they are still going to bring forth the claims that she interfered with his business and she interfered with the movie. And again, as I'm reading the 17-point agreement, nothing in here says that she gets to get her own cut of the film. I would also suspect that they're going to be providing evidence of the costs that were increased, because this was something that they really left out of their first complaint. They didn't tell us any idea, gave us no indication of how much money was damaged to them, right? Like, how much money did she cost them? So I would suspect there's going to be receipts related to the increase of how much she spent on wardrobe, and what was the cost of hiring this other producer, and what was the cost as it related to hiring a new composer and having to pay another editor, and what were the costs to the wardrobe in terms of having to drive it to her and having her not come to set for her fittings, which is an extremely expensive process. So a lot of what she was required to do is going to be exposed here, along with, I would expect that they're going to start to show what the economic damages of it were, to the tune of millions of dollars, and how they can tie her behavior to those increased expenses. And that's what they're going to have to do with the refined new complaint. Amid that, though, she still needs to be able to prove her claims of sexual harassment. And she's going to have a hard time, because we all know that she got rid of the intentional infliction of emotional distress. And she doesn't want to give up her therapy records and her doctor's records. And they just unsealed the arguments of their motion to compel, which showed her answers, which had previously been sealed. And something that is very obvious in this document is that they are still trying to get a copy of the subpoena. And it feels like they're trying to delay this, and they're trying to get the evidence that they need to prove this through discovery so that the subpoena doesn't become an issue. But the fact that she used a subpoena for this, she put in her complaint, and she said that it was a lawful subpoena. So she made it a part of the case, which is now discoverable under her amended complaint. And she is pushing back on providing a copy of the subpoena, so much so that in the responses that were unsealed by the judge, her objection was that she objected to the definition of action on the grounds that it was overbroad and that it was not relevant to the allegations, claims, or defenses in the complaint or the consolidated complaint, nor reasonably calculated to lead to discovery of admissible information, in that the definition includes Jones Works versus Abel, a litigation which she is not a party. They did a second set of supplemental documents that they were seeking, and this is very much clear that they are looking for the subpoena. They are looking for information about her creating this lawsuit, Van Zandt. They are trying to get information about what the subpoena was, what it was seeking. But she is saying that she will not whatsoever produce any documents because she's not a party to it, even though she told a court that she would show a copy of the subpoena. It even goes as far as to say that she will not produce any information on the action of the Van Zandt lawsuit or the subpoena. She is interfering in their ability to defend themselves. Her attorneys went on record and said that she was prepared to disclose the subpoena and the details of the subpoena as a part of discovery. And she says she will not produce because it doesn't involve her. But she said she subpoenaed Jones' work in her own complaint. And if she used the Van Zandt action to do so, they have a right to get a copy of the subpoena. Blake also refused to give up any of her records to prove emotional distress. And once the judge made that ruling, she and her attorneys got all puffy and arrogant, and they ran to the press and they said, "We are dropping the emotional distress claims, but we still have large money that we can make, and we can still bring in emotional distress in other claims. We can. Even though the judge in his order said by removing them from the case, she would be barred from bringing in emotional distress claims. A lot of her arrogance, I think, is starting to she's getting a very, she's being sobered right now, right? Because she has the weight of the defamation stuff off her shoulders and it can't be revived. There's going to be a new lawsuit coming, but now there's the sobering reality that she needs to prove her own case. And in a way, it kind of simplifies this entire debate with having him remove that allegation of the defamation and the civil extortion, because it allows us to focus on her allegations themselves, which, after all of that pomp and circumstance and that arrogance she had, that she was still going to bring forth these claims, she wrote a letter to the judge today and she said that they've agreed to withdraw the claims with prejudice. In the letter, it says, "On behalf of Blake Lively, we are writing seeking clarification regarding the court's June 3rd, 2025 order denying the Wayfair party's letter motion to compel and opposition hereto. By the order, the court denied the motion to compel information regarding the identity and treatment records of Ms. Lively's healthcare providers related to emotional distress, as well as a HIPAA waiver, based on the plaintiff's representation that the relevant claims will be withdrawn. She directed that the dismissal of her claims 10th and 11 causes of action for intentional and negligent infliction of emotional distress be completed by either joint stipulation of the parties or a formal motion by the plaintiff." And she writes to clarify that while she intends to withdraw her torts of emotional distress, she still pleads and intends to introduce evidence of garden variety emotional distress in connection with her other remaining claims. Miss Lively and Wayfair have agreed in principle to dismiss the 10th and 11th causes of action with prejudice. Miss Lively, however, seeks clarification regarding the court's notation, June 3rd order, that she would be precluded from offering any evidence of emotional distress if the claims are not dismissed. This leaves open a potential question about what evidence may be presented if the claims are dismissed. If she respectfully requests clarification from the court on the point before signing a stipulation to dismiss the 10th and 11th causes of action with prejudice. So she's getting nervous now, and she's realizing that if she drops these two claims, the court is going to preclude her from bringing in any evidence. And she's like, "Well, I want to claim this minor garden variety emotional distress, which is not as significant. It doesn't cause lasting damage. It's minor." And this is what they say: by dismissing the causes of action, she's agreeing to forego the presentation of evidence of treatment by healthcare providers or diagnosis for psychiatric disorders to preserve the psychotherapist patient privilege. This is a well-established right that a plaintiff may exercise in order to protect highly confidential and private physical and emotional health information while still preserving the right to pursue those emotional distress damages that are recognized as inherent in claims for workplace sexual harassment and retaliation. Remember when I said to you that it was a big deal that he said that she would be precluded from this? This is why. Because if she can't bring in any evidence of emotional distress, how does she claim that the sexual harassment was pervasive and severe? It would have had to impacted her. By dismissing the standalone claims for intentional and negligent infliction of emotional distress, she will waive the right to offer testimony or evidence of identity, records, treatments, or diagnosis of her healthcare providers related to such emotional distress, which was the subject of the discovery. The order consistent with the law and the draft stipulation for dismissal presented by the Wayfair parties, however, Ms. Lively's choice to dismiss is intended to be without the withdrawal or dismissal of any other claim, counterclaim, or third-party claim asserted therein. Thus, she's not abandoning emotional distress damages generally and continues to pursue damages for emotional distress that have been recognized as inherent in workplace harassment and retaliation, often referred to as garden variety emotional distress, as contrasted with claims that the defendant's action resulted in a specific psychiatric disorder. So she can't prove that she got PTSD or something from this. So she wants to do garden variety, which is scared, embarrassed, shamed, or humiliated, as opposed to action seeking recovery for serious psychological injury that is the inducement or aggravation of a diagnosable dysfunction or equivalent injury. So she wants to get money from them for feeling scared, embarrassed, shamed, or humiliated. That's not going to produce the huge windfall that she claims. And she said in cases where emotional distress damages are garden variety, the plaintiff may still present her own testimony and testimony of percipient witnesses who observed her emotional distress without providing medical corroboration. That includes testimony that she suffered humiliation, anxiety, stress, embarrassment, loss of sleep, loss of appetite. Accordingly, she seeks clarification from the court that should she sign the stipulation for dismissal with prejudice prepared by the wayfarer parties, the court shall not preclude her from presenting testimony and evidence of garden variety emotional distress, damages on the basis including testimony of herself and corroborating witnesses, and the scope of her waiver is as to offering testimony or evidence of the identity, records, treatment, or diagnosis of healthcare providers related to such emotional distress. So she wants it kind of both ways. She wants to dismiss having to produce evidence that this actually caused her damage and led to a psychiatric diagnosis. But then she wants to be able to show that she was humiliated, shamed, loss of her reputation. She felt hurt, embarrassed, stressed, or anxious. But because the judge said, if we dismiss this, you don't get to show any evidence of emotional distress, this is a crossroads for her. And if she can't provide any evidence of emotional distress, and if that's what the judge really means, that means even garden variety is out. And that's what I said last week. And so the fact that she's now running back to the judge and saying, well, wait, if I do this, can't I do this with the here? This is why you need to comply with discovery. So she doesn't want to prove how she got the evidence to file her claim to begin with. And she doesn't want to prove that she suffered emotional distress, but then she wants the benefit of claiming that she was anxious and humiliated, even though the judge said she couldn't do that. I don't know what the judge is going to rule. I don't know how he's going to respond. Wayfair hasn't responded to it. And because she didn't really suffer damages here in terms of the sexual harassment, because she didn't lose her job, she wasn't not paid. She was paid. In fact, she got a lot more in terms of what her contract had afforded her before. And she wasn't demoted or kicked off the set. The state of California, to successfully claim it under California law, the person is liable only when there is a business, service, or professional relationship between the plaintiff and the business. And that includes a relationship with a doctor, an attorney, a teacher, elected official, or an employer. And then the defendant has made sexual advances, solicitations, requests, or other conduct of a sexual nature that were unwelcome or pervasive and severe. She's going to have a very hard time proving pervasive and severe. And as a result of such conduct, she has to prove that she suffered damages. That would include economic damages, such as loss of earnings or medical expenses. So she's already said, I'm not going to show you that I went to the doctor. And we already know that she wasn't damaged economically via the sexual harassment because she got paid. And the non economic damages would have to be related to pain and suffering and emotional distress and humiliation. So, in order for her sexual harassment claims to move forward, she has to be able to use evidence of emotional distress. That's why I said when he made that ruling against her, it was a big deal. And I didn't think she really understood. It means the retaliation claims and the sexual harassment claims could easily become dead if he removes all of it. And while the judge was firm with Justin's case, I think Judge Lehman is tired of both sides, quite honestly. And I don't think he really believes either side in terms of the allegations they brought to his court, which is why I think he keeps calling it a battle of PR agencies. because he said, if you don't do this, you can't prove this. And if she can't do any emotional distress, she won't be able to prove that she had any damage for the sexual harassment, and she won't be able to prove that she had any damage for the retaliation because it's an element that is needed to prove liability. By removing those claims last week, she basically removed expert witnesses and testimony that could speak at trial as a witness to verify with the court under penalty of perjury that she was damaged emotionally, like a psychologist, a therapist, a mental health provider. But Garden Variety relies on her own testimony and friends' testimony. And that can easily be poked at and destroyed through credibility issues that she has. And they're going to be able to, against what she says she felt, they'll be able to show evidence whether or not she meets that. Like if she said, well, at this day, I felt this way and it was on camera, or I couldn't do this and I couldn't do that. And then they can be like, well, I have 14 pictures of you out on red carpets. Or they can poke holes in her credibility other ways. If we're going to rely on her for credible testimony, she's going to get destroyed. That's why she needs an expert to verify these claims. She needs a benefit of someone that's not her. And that's why these claims are going to fall apart. She really screwed up, really screwed up. And her desire to have it both ways is going to blow up in her face. And on top of that, I want to be clear, Garden Variety emotional distress does not pay out anywhere near what she would get if she were to have the intentional infliction of emotional distress. We're talking in the state of New York under this, they are a scale for those types of claims on Garden Variety is like 50 to 150 per claim. So 50,000 to 150,000. Whereas intentional infliction of emotional distress can be at minimum 200,000, 300,000 into the millions. So she's limiting herself to a couple $100,000 versus millions of dollars by removing those claims. And think of how much money she is spending on this lawsuit. She thinks that she's going to get this windfall, but by removing the big emotional distresses, which what I told you, she's removing all of the damages. And then she was so arrogant to say that she was going to get treble damages and she was going to get all this money because they brought the defamation claim against her and retaliated against her. The judge already said he's not going to award the treble damages. She thought she was going to get this as almost like, I don't know, a money grab, and it blew up in her face. And her case really is hanging on by a thread. So on the one hand, yes, are we upset about what happened with Justin? Yes, but equally, the judge is not moved by Lively either. So what are your thoughts? We'll have to see how the judge rules on this. But tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.